As the court has repeatedly pointed out, Mr. Demons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight for him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
YNW Melly's high-profile retrial is just 4 months away, but the defense is hoping to get him out of jail on bond before that happens.
6 years ago, spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically.
I'm Elizabeth Millner with Law&Crime. Jamell Demons, aka YNW Melly, has been in a Florida jail since his arrest in 2019, so more than 6 years ago. And in that 6 years, Melly went on trial, which ended in a mistrial after a hung jury. And despite facing 2 charges of capital murder, the defense is still pushing for bond and offering a number of compromises if the judge allows it.
There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
It was a packed courtroom this week, mainly of Melly's family, when the Florida rapper appeared before a Broward County judge. And before the judge heard arguments about why Melly should or shouldn't be allowed the chance for bond, the judge heard from the lawyer of the victims' families first.
I think the victims, the family members, just wanted us to at least place an objection on the record. Let their feelings be known. Of course, under Marcy's law, they have that right. And so we followed that objection just so your honor knows what their position is, what our position is here, that we would be, and the family members would be objecting to any release in this case.
The defense tried to call a witness to the stand to testify at Tuesday's hearing. It was Dr. Heather Holmes, a forensic psychologist, but the state wasn't about to let that happen.
We're going to be objecting to Dr. Holmes' testimony just because she was noticed in the state less than 36 hours ago. She's going to be testifying as an expert. We don't know what documents she was relying upon. We don't know what materials she was given to review. We've been provided no reports, nor do we know the substance of her testimony.
When was she listed as a witness?
She was listed, I believe, Friday evening after we had hired her. The state wants to make a 10-minute break. We can talk to her. There was no report.
She was listed
Sunday night.
Stop. Okay. You listed her Friday afternoon.
I believe so.
Okay.
Your Honor, I can tell you the court filing came in and it's on Odyssey from
Okay.
it's about Sunday evening.
So you don't want her testimony to be considered today in the evidence?
We're fine bifurcating once we, have enough time to know what she's going to testify to, know what she relied upon, have time to look into that. But today, with, as Mr. Griffith said, less than 36 hours, we're not at all prepared to have an expert testify.
Is she in fact testifying as an expert?
She's testifying as to basically the second portion of my motion, going to the appropriateness of the bond. So I am tendering her up there. She did sit with them. She has information to provide to the court.
She interviewed your client?
Yes,
And she's going to testify about that?
Yes, Judge.
And just so Your Honor's clear, the e-filing from the court, the clerk's portal came in at 10:31 p.m. on 5/4, which was Sunday evening.
Okay, so the state's objection is sustained. She's not going to testify today.
So a loss for the defense there, but the lawyers still need to do what they do and argue their reasoning.
The circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release. If the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight. Is he a risk of flight? So going through that, what we would be proposing for Mr. Demons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor for GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged to one, it was twofold what I had asked for. Mr. Demons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Demons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. You basically have your own deputy, paid deputy, with him. Mr. Demons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm.
So GPS tracking, a 24/7 security guard, money to post bond, that pretty much sums up what the defense is offering. But Melly is also charged with witness tampering, something the judge will likely take into consideration. But the defense had an answer for that too.
That case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demons' trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person, but there's no proof of it. We deal with, and I was based off the previous motion not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital crimes, lifetime crimes, right? And you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital crime. So I did some research on that. And the whole basis for it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not, did anything. He did the right thing, Judge, and he turned himself in. I believe February 13, 2019. 6 years ago. Spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23-1.
Counsel, I hate to interrupt you, but there's no evidence of that.
Okay.
The lawyers don't give evidence, so if you want to present some evidence, I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I can't consider it.
Okay, Judge.
You're just saying it, so go ahead.
So, the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community. See his mom, his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That prove evident, great, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those 3 things? To make sure he's present here. To make sure there's no harm and the integrity of the judiciary. I don't have any evidence before you. We were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demons could go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the court, of the judiciary. And I believe we have met it. The state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant. It's to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be protected.
And what was the state's response? Well,
The defendant's charged with homicide. He's killed 2 people, so he's clearly proven himself.
Allegedly.
He is.
Please, one at a time. Go ahead, sir.
He's already established that he presents a danger to the community, but not only that, he attempted to tamper with witnesses while in custody. It's actually the reason Mr. Henry is back in custody, because he did have a bond and that bond was revoked. Had Mr. Demons been on bond, his bonds obviously would have been revoked and he'd be back in custody as well, because there is probable cause that a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites all recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Demons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
Okay.
May I respond, Judge?
Okay, last word, go ahead.
So, as to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. I can give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be if there was a monetary bond in place, his record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label. He is actually duly employed. He has a recording contract. He would be able to work and have a source of income. And we'd have conditions in place to ensure. As far as what the state's arguing that they're afraid he would flee, I again think we alleviate any concerns when I put security on him. It would be essentially a private cop monitoring him 24 hours a day and another individual monitoring the property. They would be reporting back to not only the defense team, but to the state attorney and to the court if there is any issue. Again, the ankle monitor is being monitored. I've had other clients on GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Demons, while being on house arrest and a GPS tracking monitor, had absconded to another country is basically ludicrous, Judge. It's an impossibility. It cannot happen. We have met the factors coming under those three different combined statutes. It's protecting the community, protecting the integrity of the judiciary, and basically making sure that he shows up to court. I believe we have proffered enough for the court to basically be able to rely on the fact that he meets those factors. The state has not raised any additional factors that would say, all right, he's not eligible for the bond.
Despite a packed courtroom, likely hoping the judge would make his decision right then and there, Judge Fine instead is going to hand down his ruling in the next few days. But the bond issue wasn't the only matter brought up in court on Tuesday. A lot of the other arguments had to deal with what will be admitted into evidence during Melly's retrial, because remember, there was a different judge on Melly's first trial.
As to the first motion to suppress the T-Mobile records, that was denied. The cell phone location records where the defendant was that day with his phone moving around, that remains in evidence. As to the second warrant, the Twitter account that was granted in part, the past events from leading up to the homicide were suppressed, which means the admission that was made on Twitter is kept in, but the aggravators relating to the defender's activity and belonging with gangs and his gang membership, that would be out. As to number three, the iCloud, that was granted in part. I think we noted that there was nothing of import there, so we weren't using anything from that, or we didn't recover anything from that. To the Snapchat, that was granted in part, again, the day of the homicide, so the location information, the communication records from that day remain in. The messages from the defendant's ex-girlfriend, Mariah Hamilton, those occurred afterwards. Those would be out, but those were not introduced in the first trial. We do intend to use them, but those were not in the first trial.
Just when you say out, I don't understand. I just want to make sure.
Out. Mariah Hamilton's the text message.
When you say out.
Out, as in they're not in evidence. They were suppressed.
Oh,
It's subject to suppression. It's subject to suppression.
I want to make sure out that it was suppressed. Thanks.
As to number 5, the Google records, that was denied. As to 6, the Facebook account, that was granted in part. Physical location, FaceTime info, connection information, photos from the homicide up to when the warrant was suppressed on January, or when the warrant was applied for January, that remains in. So what the state lost there potentially are photographs related to gang-related activity, the defendant's membership in gangs, as well as some comments and communications about the defendant promoting the promotional video, which is also subject to the appeal because we argued adoption by admission because he was promoting that video. But all those communications were after January 8th, or at least some of them were, I think. The Instagram, which was number 7, it's effectively the same thing as the Facebook, the gang activity. Number 8, the T-Mobile records, the real-time location information, that was denied. Number 9, the T-Mobile records for historic location information as to the defendant, that was denied. Number 10 is moot because it was the wrong phone. The detective got a new warrant. Number 11, the defendant's iPhone, it was granted in part from the date of the homicide up to February 13th. So we obviously kept anything that was backed up to that phone, including the pin drop information, some notes, some text messages in reference to gang activity. But what we also was suppressed were some of the notes and text messages from the past relating to gang activity. Where'd it go? Number 12, the Google accounts. There were 2 accounts. We lost everything prior to the homicide was suppressed. That includes gang-related information as well as the gang Bible that was recovered from his account. And in number 13, which is what Ms. Collins was checking, the YNW booking. I actually didn't know offhand what was actually suppressed from that, but I believe it's more gang-related stuff. So effectively what was suppressed was a lot of the stuff the state would be using for aggravators.
With the cell site location information
Remains in.
from October the 26th, 2018, none of that was suppressed.
Correct. And that's my summary. If they disagree, because I was trying to prepare this for today's hearing, I didn't have the time to go through every piece of evidence.
Okay.
I think it was the same of what I said, but just to go a step further so the court understands, I agree with what the state had proffered as far as what's suppressed. Going to what specific witnesses testified to what we agreed was suppressed. You'd be looking at the majority of the testimony from Danny Pula would be out. He testified to a lot of the photographs of Mr. Demons' phones that predated, as Mr. Griffiths has said, the booking, the YNW booking, Jamell had a gang Bible sent, some gang talk sent to that Jamell. All of that is out because it predates the murders. That is most of what Danny Pula testified to. The second witness who would have testified to certain messages, maybe with Mariah Hamilton, Detective Mark Moretti testified to a substantial amount of text messages that would now be suppressed. So I believe we said close to half a day where he just read text messages off of the screen. Most of that would be out.
How about the text messages from October 26th? Were there any?
Those would remain in. As far as his phone is concerned, it was granted in part from the date of the homicide to February 13th remains in.
So what does all the legal back and forth really mean? Essentially, the state still argues they have a strong enough case, even with some of the suppressed evidence out.
We believe that proof evidence still remains strongly present because, as the court was noting, all the information from the day of the homicide remains. So the vast majority of the evidence that was introduced at the previous trial remains available to the state. What the state effectively lost, as I summarized, were a lot of the enhancers that were used, such as the gang activity, some of the information that goes to motive. But for the day of the homicide, the ballistics that shows that the shots were fired from inside the vehicle, the fact that Mr. Henry lied about the events, which was corroborated by the locations that were determined where the shooting actually took place, for the shell casings that were recovered, the fact that the defendant's phone was traveling with the 2 deceased in this case along with them and then separated prior to Mr. Henry going to the hospital, the admission on Twitter that the defendant made where he said, "I did that." All that stuff that relates to the homicide, to the direct evidence for the guilt portion remains in evidence. So effectively, nothing has really effectively changed other than some of the arguments that the state can present to the jury in terms of both aggravators and motive.
So before I hear the defense's argument, based on their written pleadings, I suspect they're gonna get up and tell me that since the jury didn't find him guilty of these, that's beyond a reasonable doubt. We weren't able to do that to the jury, so you're now asking me to find a higher standard, that is proof, evidence, presumption of guilt. So do you have any response to that?
My response would be is that it was a hung jury, and my understanding is that 11 of the jurors were ready to convict.
I have to object to that.
I have no idea what this is.
That it was a hung jury, and we don't know what their decision was.
It was, Judge, I have to object to the characterization that we don't know. It was mistried because they couldn't unanimously decide, which is the standard by which somebody is found guilty or innocent. So,
No, I'm not considering votes. It was a mistrial. I got it. Anything else?
No.
Okay.
As I always say, we'll see what comes out of this and what happens next. Melly's retrial is expected to begin this fall. YNW Melly's next court hearing is slated for late June. As for his retrial, that's set to start on September 10th. Reporting for Law&Crime, I'm Elizabeth Millner.